This week we're talking about our mental health courts, and these are the reaction to all of the issues that we've just discussed in the last, 12, 13 weeks. The traditional criminal courts have fallen short of addressing, and we have seen this throughout, how to prevent future occurrences of behavior by persons with a mental illness. Some attorneys actually believe it's easier with less interference from authorities to serve a shorter sentence as opposed to being compliant with longer-term treatment processes and conditions, such as the mental health court. As we've seen in the last weeks, that putting those with a mental illness in traditional criminal justice system and traditional incarceration just increases their symptoms and their mental health diagnoses. But these specialty courts that we're going to talk about have emerged, and we're not talking about just mental health courts here. When I say specialty courts, problem-solving courts, juvenile justice courts, juvenile courts are actually considered a specialty court, but we're talking about drug abuse courts, veteran courts, mental health courts, domestic violence courts, anything that deals with a specialized crime. And these emerged in an attempt to solve all the problems that are associated with these specific populations. Defense attorneys and prosecutors are often hesitant. Defense attorneys are often hesitant to embrace the principles of therapeutic jurisprudence that we've been talking about and enlist their clients in the mental health court process. However, Kramer and Cohen, they maintain that prosecutors are actually more likely than public defenders to make referrals to the mental health courts. Thomas Jefferson said, "Nothing is more unequal than the equal treatment of unequal people." So when you think about this, think about how this would apply to the mental health courts. Criminogenic risk factors. Relying upon the work of Andrews and Osher and Taxman, they constructed a list of 8 central risk factors that you can find in Table 1. And those are the history of antisocial behavior, antisocial personality pattern, and antisocial cognition, antisocial attitudes, and family or marital discord, poor school or work performance, few leisure or recreation activities, and substance abuse. You see all of these when we're looking at those that have a potential for the risk factors for mental health diagnosis. As noted by Scheme and Osher, offenders with a mental illness tend to have more of the 8 criminogenic risk factors that were identified. This in turn is more likely to propel these people to the attention of authorities, the law enforcement, criminal justice system, and these people are less likely to comport themselves and are more likely to spend longer periods of time under the control of the justice system and spend longer terms in prison, as we've noted. Without a proper intervention, for instance, like the mental health courts, these individuals are destined to become high utilizers. They're destined to stay within the criminal justice system. Howard Finkelstein is a public defender, and he, along with Judge Lerner-Wren in Broward County, they conceived this concept for a specialized mental health court. And although some claim that it was originated in 1980, it was actually established in 1997 in Broward County. And Judge Lerner-Wren was actually recognized by the president during that time and brought into Washington to discuss her designation and her design along with the other stakeholders of the mental health court. Generally, drug courts are actually more punitive than mental health courts, and the drug courts began in California. Both mental health courts and drug courts rely upon the principles of therapeutic jurisprudence, as we are well aware. As we've talked about before about crisis driving policy, for instance, an individual who had suffered a traumatic head injury heard voices in the store, ran outside into a little old lady knocking her over and her bag of groceries to the ground. They observed him trying to put the groceries back into the bag, but they thought he was trying to rob her. And so the lady ultimately died from injuries sustained in the fall, and the fellow with the head injury was actually indicted for manslaughter. Finkelstein, the defense attorney, implored the grand jury that if they were going to indict his client, They had to indict the whole mental health and criminal justice systems for failing the man time and time again. The grand jury launched an investigation that resulted in a report that lambasting both the mental health and the criminal justice systems. The grand jury's recommendations provided the lead to the establishment of the Broward County Mental Court, as well as the case was initially heard in a traditional courtroom, which is where it normally occurs, and the man had just been released, and he was having distortions. Could not. He believed that he was about to be married to Joan Rivers. He was waiting on a stretch limousine. The hospital called the police. He was arrested, and the judge did not appreciate his profanity and charged him with contempt of court. As I just talked about, Judge Ginger Lerner-Wren, she is the nation's first mental health court judge. She actually saw the number of individuals with a mental illness coming through her traditional criminal court, as well as the high level of suicides and deaths within the Broward County Jail. Although Broward County's mental health court is considered the first mental health court and was the design and the model for other criminal courts, there's no single ideal model. Much depends on the services available in the area, the jurisdiction, who's willing to come to court, the services within the community. In a survey of mental health courts, the Council of State Governance reports that in 1997, there were only 4 mental health courts in the country, but by 2004, there were 70 courts known to be in operation. In 2007, according to Stedman, there were roughly 150 mental health courts in operation across the nation. And today there are more than 250 mental health courts. You should check out your jurisdiction and your community and see if there is a mental health court there. I also want to say that Judge Lerner-Wren, what she did along with the defense attorneys and as well as other stakeholders, they all got together. And this is why I've talked about before about stakeholders and getting together. And I think you'll see that, you saw that on your midterm, that it's a collaboration, and you can't have just one or two people that are willing to make change. You've got to have all the stakeholders that see an issue and are willing to make a difference and make the changes that are needed. The majority of mental health courts are located in the southern and western states. 41 specialized juvenile mental health courts have been identified in 15 states. We talked a little bit about this during our discussion on juvenile mental health courts. A few mental health courts actually have programs focusing exclusively on families, and one of the longest established programs is the Behavioral Health Court in California. There's a federal mental health court in Salt Lake City, Utah. The mental health courts have a specialized docket. They may or may not accept guilty pleas and or findings of guilt. They may or may not accept misdemeanors or felonies. The first mental health court with Judge Lerner-Wren, she did not accept felonies within her courtroom. I think now it depends on the level of the felony. They generally include status hearings, can ensure accountability of mental health providers. The mental health courts involve not just the judge and the attorneys, but also mental health providers within the community. It involves the family and other participants. It can involve probation officers, parole officers. This can prove beneficial because, as I said, with the influx of the persons with mental illness into the system, the public mental health systems need to shift costs and local state correctional facilities. The mental health system is known for dropping its problems on the courthouse steps, as we've talked about numerous times. The contempt of court citations, one mechanism to gain compliance from the treatment providers in managed care in order to get these people the help that they need, has been associated with a reduced recidivism for graduates of the mental health courts. The model's mental health court teams are composed of a judicial officer, treatment provider, case manager, prosecutor, defense attorney, some cases probation officer, and I said sometimes the family is involved. There's two generations of the mental health courts. First one was more punitive, more misdemeanor focused. As I said, they only dealt with misdemeanors. They avoided convictions and really relied on the clinicians to help these individuals. The second type of generation was not restricted to the nonviolent misdemeanors and was more likely to employ a post-adjudicative format, utilizing supervision affiliated with the system. In other words, there was a collaboration of the juvenile, the court officials along with the mental health professionals. And as I said, initially the courts took only misdemeanors, but now they take felonies. And according to Judge Hirsch in Queens, all cases are for felony offenders. Almost all cases utilize pre-plea diversion, and all benefit from a dismissal or reduction of charges upon successful completion. I also want to say that in Judge Lerner-Wren's courtroom when she began this, and I posted some videos of Judge Lerner-Wren, and some of them are a little long, and you're welcome to review them all or some of them. But what she did within her system, she didn't necessarily see herself as the judge or the one in power. She saw herself as a part of the system, as really the facilitator of the services. So, and she had an open communication within the courtroom so that they could help this individual and keep them out of the incarceration. Mental health courts, criminal courts in the U.S. have traditionally considered mental illness in terms of competency and sanity, not recovery, as we have talked about. There's an estimated annual admission to jails of 2 million persons with a serious mental illness in the U.S. Some advocates believe with proper intervention, and at least 1/4 of such persons could be properly treated in the community instead of incarceration and instead of involuntary hospitalization. As offenders appear before such courts, the question is not, what is this case about, but what brought you here, why are you here, how can we help you? The focus shifts from being solely on the individual to consider the circumstances that may contributed to propelling the person. So instead of looking at their behaviors, their criminal behaviors, it's looking at the why. Why did they commit these behaviors? Mental health courts are a different approach. They're a therapeutic approach. Traditional courts focus on legal issues. The judges act as an arbitrator in the traditional process, but as I said, more as a coach and a facilitator in the mental health courts. The focus of mental health courts is on therapeutic jurisprudence. The traditional system, formal, legalistic, efficient. The mental health courts are more informal, commonsensical, and effective. There are some concerns, and you read these when you read any articles on mental health courts, and it's really you have concerns when you do anything different. Some have argued that the informality of the mental health court and the lack of the adversarial process really results in a diminution of the individual rights that needs to be preserved. Some express concern that persons who are identified as mentally ill are processed through a specialized mental health court docket, and they can be stigmatized, and we know what the stigma does to a person with a mental illness. Some insist that mental health courts may actually result in the criminalization of people with a mental illness or widen the net of criminal justice control over citizenry. It's really bringing this to the forefront. Bernstein and Seltzer, they recommend that the mental health courts only be utilized when individuals are facing significant jail or prison time. Judge Lerner-Wren would actually disagree with this. Within her court system, she is actually very open and very available to law enforcement when they're dealing with a person with a mental illness, because they are the forefront. They are on the front lines, and so they're the ones that originally deal with a person with a mental illness. And but she recommends that they call her. So, and law enforcement do when they have interaction with a person with a mental illness, they can call Judge Lerner-Wren and get this person admitted into a therapeutic environment instead of the Broward County Jail. A number of scholars have questioned whether mental health courts are coercive, as they question whether a person who is mentally ill can even make a rational or competent decision. But remember, again, that's why you have so many advocates for that person within the court. They're not there by themselves. They've got mental health professionals, family members, even friends that can possibly help them with the understanding. As we've talked about throughout this course, Bruce Winick is considered one of the pioneers of our therapeutic jurisprudence movement, and acknowledges that some alternatives like assertive community treatment and police diversion programs may indeed be better interventions than actually mental health courts. However, though, he favored the use of mental health courts over the criminalization of persons with a mental illness. Remember, he was a huge advocate for the human rights of those with a mental illness. An advantage of a mental health court over the traditional court release from jail is the ability really to oversee the therapeutic progress of persons with a mental illness upon their return to the community. In other words, when someone is released from a traditional jail, as we know, they're usually given, a minimum amount of money, if any, and just let out the front door. But that's not the case with mental health courts when they're released from, whether it's jail or treatment. They're connected with services within the community. As I've talked about a minute ago about the Judge Lerner-Wren and the mental health court judges, they are acting as gatekeepers to treatment for those with mental illness. Courts can hold managed care authorities in contempt of court for failure to comply with treatment orders. So they can, even though they order a treatment, the treatment provider many times doesn't follow through, or the person with a mental illness falls through the cracks. But a mental health court judge has a little bit more power in that area. Talish, he's described mental health court judges as risk managers, functioning almost like social workers. And remember Bruce Winick, how he said that everyone within the criminal court system is a social worker. It's a helping profession. And here again, with a shift towards healing and away from retribution. There obviously are initial costs associated with everything. Mental health courts may seem excessive to some. The initial outlay of resources and personnel costs of a mental health court may be higher than the current total expenditures. And remember, we always see this, that they're relaying the cost, but the overall cost of a mental health court and initially guaranteeing treatment and services to antipsychotic medications may be more expensive, and we've talked about this before, than merely putting them in jail and having them mentally decompensate. However, as we say, the long range objective is to prevent people from recycling through our system, and therefore does reduce overall cost. The Rand study, 2007 Rand study, the total cost savings, they found, the total cost savings was $9,500 per participant, which is a $500,000 savings over 2 years for those that participate in a mental health court. Initially, the mental health comprehension is predictive of future success or failure in the mental health court. The competency testing, and when we talked about the competency to stand trial, this is still, it's how it's measured and how it's evaluated. One aspect of competency to participate in mental health courts is the comprehension of the limits to confidentiality. Because you're now involved in a court system, the confidentiality of your mental illness is at risk. And so what are we looking at again? We're looking at the stigma of being involved in these court systems, as well as the stigma of being labeled a person with a mental illness. There's a number of ways in which individual rights can be safeguarded. Competent individuals appearing before the court can sign waivers. Mental health court judges can limit inquiries so that no Fifth Amendment rights regarding self-incrimination of defendants are violated. By focusing more on the mental health of persons before the court. Family members of persons with a mental illness who are not bound by the doctor-patient privilege can prove to be a good source of information, because remember that within the courts they might have trouble finding a history or a background of the person in front of them, and this is due to the HIPAA violations. Mental health clinicians used by the court can facilitate the dispensing of information from one mental health provider to another. Additionally, via interagency computer networks, jailers can apprise mental health providers. Law enforcement officers, because they're first responders, are actually exempt from the Health Insurance Portability and Accountability Act, or HIPAA, and have an obligation to meet the mental and physical health care needs of individuals while in their custody. And remember, this is the issue of HIPAA and the issue of the stigmatization. We see this issue all the time. In fact, there was a case just recently of someone that fell through the tracks that was diagnosed with a mental illness after being released from the Marines, who killed 11 people plus himself in California in that college area bar and grill. And some of that is because if we listen closely, he did not meet the criteria for dangerousness in order to be involuntary hospitalized. But then again, because of the HIPAA violations and the restraints, he was able to purchase a firearm, because as we know, when you purchase a firearm, there is no connection to a mental health or the mental health system. Successfully completing a mental health court program does not guarantee, though, that the participants will steer clear of the system. Overall findings, though, reveal that when outpatient treatment is mandated, either through the courts or other statutes, these persons tend to do better than those that are non-treated. It would behoove of administrators and benefit taxpayers to explore more fiscally sound and effective alternatives to incarcerations through these mechanisms such as the mental health courts. Again, let's reiterate that we know that it may cost more money up front, and we see that even when we're initiating programs in schools, in the community, in our prisons, in our correctional system, within our criminal justice system. But overall it pays off because it reduces their interaction with the criminal justice system within the future. Mental health court judges, they can actually help negotiate and navigate treatment services, but really because they must rely on what's available within their community. They can't create new services. They have to learn to prioritize the services. This is why those that are involved in the community services, those that are community care providers, are included within the mental health court process. So I just want to end here with reiterating the importance of these problem-solving courts, especially the mental health courts, because when you think back on those that have committed horrific crimes, that have been diagnosed with a mental illness, but have not reached that level of dangerousness in order to be involuntary hospitalized. And as we know, you cannot be involuntary hospitalized for an indeterminate amount of time, but that it boils down to, are there the services available within the community? And these that are diagnosed, think if they had been processed through the mental health court with their initial behaviors, and whether or not they were actually criminal, would they have been involved in a community program? Could the mental health court judge have really helped these individuals and to get connected with community services so that they are involved? Because we do know that it does prevent future occurrences of the same behavior.